Hey guys, how are you?
Gary's got twins.
So maybe we can put it like on one of these chairs.
Yeah. Wherever do you mean? Just put this right here?
Yeah. Yeah, I got it.
That's well, this is power.
Room somewhere I want to do.
And I can plug this into the receiver right here, right?
Yeah, we just bring that for you guys.
Do it with that. Thank you.
You got it, man.
ready to go? Ready? All right, let's get on the record, please. Again, this is State of Florida versus Demons, President is the defendant, his counsel, and the assistant state attorneys. I guess which motion went to take first, guys?
Joel Silverstein on behalf of the state. Morning, Your Honor.
Morning.
I filed a motion to quash the subpoenas of state attorney Kyle Pryor, chief assistant Ms. Hall, assistant state attorney Ms. Killian, and assistant state attorney Klinger, assistant state attorney Ms. Bachelor. I'll tell the court up front, I am not quashing the subpoena of Michelle Lucas. I have several reasons for this particular motion. First of which is this court issued an order on October 12th of 2023 quashing the subpoenas of Mr. Pryor, Ms. Falk, and Mr. Killoran. And the defense in this particular matter has not asked this court to lift that protective order that the court granted. There hasn't been. So the state's position regarding that is that the protective order is still in play. And that the issuance of the subpoena was a violation of that protective order. Even if the court finds that the protective order doesn't cover these particular witnesses, the state would argue that the reasons for quashing the subpoena in issuing the protective order have not changed from the second motion to dismiss to the third motion to dismiss. And there's nothing in the third motion to dismiss which would indicate any change in testimony, any change in position of the board, any position of the state in allowing which would require their testimony. Regarding Mr. Klinger, who's the only person who was not mentioned in the first set of subpoenas, Mr. Klinger, as the court knows, was arguing some of the matters in this case with the court. The only attachment to the motion is a portion of one of the hearings where Mr. Klinger cross-examined his uterus. And the only issue regarding cross-examination had to deal with clarifying her testimony regarding whether or not she was part of the prosecution of the homicide case as opposed to the tampering with the case regarding this case. But there's nothing in this motion which would allow Mr. Klinger, which would prevent this court from granting a motion to quash this particular matter. Mr. Klinger is a witness. He's not a witness in this case. He's one of the prosecutors in this particular matter. And under the prevailing case law, which I have cited to this court in my motion, that there is that this court should quash the subpoena and issue a protective order towards him as well. As far as Ms. Bradley is concerned, this court has already heard testimony from Ms. Bradley. But since the court removed her as the prosecutor, since she's been removed as the prosecutor in this case, there's been no allegation of any substantive conduct regarding Ms. Bradley. So there's nothing at this point in time in which she would be subpoenaed. And there, so consequently, the motion should be granted on that particular basis. The court will have the ability. The defense is not going to be prohibited from whatever inquiry that we're talking about because we have not sought to quash the subpoenas to be traced. I'm not here to argue the motion to dismiss, but there are certain facts which come in motion which I do need to address. First of all, any information from Mr. Pryor and the assistant state attorneys in the course of their employment as state attorney, independent of the state attorney's office. And also under Donaldson, the defense in this case, this is not the rare case in which the defense believes it has a basis for taking testimony from the prosecutor and must engage in less intrusive methods. So if they have Ms. Boutros testify in this particular case, and I'm not here as Mr. Harrison have to prosecute the motion, and whatever information can come from her. This is not a unique situation where the only person who can testify is Mr. Pryor, Ms. Hall, Mr. Killen, Ms. Bradley, and Mr. Cole. This is not one of those situations. Other than that, Judge, I would rely on my motion. I would ask the court to grant the motion of why to enforce the previous protective order, and the court does not feel that the previous protective order covers this particular matter, and that they should protect the order in this matter.
Thank you. Yes, sir.
Thank you, President. First of all, I do not believe that protective order does include this round of subpoenas. If it does, then I would be asking that you quash that protective order and allow these subpoenas to carry the day, so to speak, in the event. A lot has changed since the last time we discussed these issues. Before I go into that, I want to point out, we're not just moving to accuse the state attorney's office. We're also asking for this case to be dismissed, basically pretty much on the same grounds. But those are two different things, recusal and dismissal. Since this last was heard before the court, as I said, a lot of things have changed. First of all, we subpoenaed these witnesses through the state attorney's office because that's the only way we can subpoena. But I don't know if these witnesses were even ever informed that they got subpoenas. But I do know that the state has not established standing to represent these individuals. They are individual people. Ms. Boutros wants to testify. She is willing to be here. I don't know about these other people. The state has not represented that they are the attorneys for these people. They are he is in the state attorney's office. But each one of these people have their own individual rights. And they have also their own obligations to say, I do not want to testify, or I do want to testify. I want to invoke a privilege. I don't want to invoke a privilege. I don't believe Mr. SakChaser can do that for them. They're individuals. Next of all, Your Honor, as I said, a lot has changed since we last were here. When we were here discussing these matters, Mr. Klinger represented to the court that if Ms. Boutros testified, that the state would not cross-examine her and that she would be left to say whatever she was going to testify to. When she testified during the motions to suppress, Mr. Klinger did in fact question her. It was 2 or 3 innocuous questions, pretty much, but did not go into credibility or anything like that. It was to clear up a simple matter. The state represented, not to us, Your Honor, but to us, meaning you and everybody, that they were not going to cross-examine. Yet, we know during the motion to suppress, she was subject to a brutal cross-examination. And then the state files in their state's response to the defendant's third motion to dismiss for violations of due process and double jeopardy and or motion to recuse the entire state attorney's office of the 17th Judicial Circuit. And they filed with that document. And on page 13, number 26, they state, the defense raises the issue that the state agreed to not cross-examine ASA Boutros. This was a true statement, at least initially. However, as ASA Boutros testified, concern grew regarding her recollection of the facts. Even the ASA handling the first motion to dismiss determined he had to do a limited cross-examination of ASA Boutros. The redeposition of Detective Moretti only compounded this issue and prompted further investigation. The state cannot be expected to curtail its own case in light of evidence that comes forth. The prosecutor's duty is to seek the truth regardless of the identity of the witness. It's also the prosecutor's duty to keep their word to the court. In fact, that may be one of the highest duties that a prosecutor has, is that when they represent something, to follow through on that representation. But this state attorney's office did not do that. In fact, they are brazen enough to put in their pleading, yeah, we did make that representation, but our representations mean nothing if the events change later on, because if it suits us, those representations are worthless. So that has changed. The state had told this court, maybe it was part of your analysis, maybe it was considered in your ruling, but the state told us back then that they were not going to subject her to cross-examination.
And, counsel, I would just indicate to you, take a look at the order that I signed on October 12th, 23, on the order denying defendant's motion to recuse state attorney's office. On page 8, at the bottom it says, defendant has failed to demonstrate how he will be prejudiced by the state attorney's office prosecuting this case, notwithstanding Ms. Boutros and Ms. Bradley's testifying in trial, particularly in light of the state's representation that they do not plan to attack the credibility of Ms. Boutros for trial. It's in my order.
I thank you for doing my job. I should have caught that myself. But that's what they represented, and that's not what they did. And now they're telling us their representations mean nothing in the future. So that has changed. What else has changed? When we were before the court before, the state kept on arguing that the tampering and the murder were not related. And I think the court kind of thought it was related. In fact, the language in the order seemed to indicate that it wasn't a hard and fast thing that they are related. But then the state filed in their motion for rehearing reconsideration that they filed on the motions to suppress on page 19. I'll read from the middle of it. It should also be noted that the defendant has subsequently been charged with witness tampering as well as directing the activities of a gang in State versus Jamell Demon's Broward County case number 2310594 CF10A. The information relied upon outside of the scope of the court's ordered timeframe would have been found during the investigation of this case as well. The new charges inherently stem from the original homicide case just by the nature of the charge. This means that the evidence is inextricably intertwined with both cases. And that comes from the state. The same state attorney's office that has been telling you that they're not related, then puts in a pleading that they're intertwined and interrelated. So that has changed since the last time that you heard these arguments on it. So we've had a lot of change in the circumstances. And I think, so that gets us there. Since that time, the state has put in the record now everything that they can find about Ms. Boutros. They have disparaged her reputation like I've never seen done by any office to anybody that works for them. And I think that goes inherently to the institutional violations of my client's due process. You have an office that is willing to do anything that they can, but that's getting to the motion. I just want to get to the quash, so I'll back up this. Again, I raised standing. But more importantly is waiver job. I'm sorry,
Not a problem.
okay. So, I'm looking through the evidence code, I'm looking at things, and I come 507 of the Evidence Code says waiver of privilege by voluntary disclosure. A person who has a privilege against the disclosure of a confidential matter or communication waives the privilege if the person or the person's predecessor, while holder of the privilege, voluntarily discloses or makes the communication when he or she does not have a reasonable expectation of privacy or consents to disclosure of any significant part of the matter or communication. This section is not applicable when the disclosure itself is a privileged communication. I want to reiterate that last part, or consents to disclosure of any significant part of the matter of communication. They have consented to Ms. Boudreaux's testimony. They did not file a motion to quash. The last time that this case was up, she testified. She's testified twice. The state has allowed that to occur. They've consented to it. Therefore, this matter is not totally open for all the testimony and revolving around the same testimony that Ms. Boudreaux did. But there's more, Your Honor. If you look at their Brady notices, I have them here if you'd like to see it.
I've seen them.
I'll just read.
If I need to see it, I'll take a look at it.
In the third Brady notice, the one that is on, the one that was issued by Christopher Tillerin on the 26th of September. I'll read the last paragraph. The lead SAA assigned to this matter relayed to the state attorney's administration as she spoke with Detective Moretti in regards to this incident. So I'm going to stop right there. So they've already acknowledged the communication, that there was communication in this matter to this incident. The detective already explained that his statement to the Deputy Garl was a joke. So they have now told us there's a matter for us to have to look into. The lead ASA subsequently filed a Brady notice with the court on September 23rd, which stated that Detective Moretti told her that Detective Moretti asked Deputy Garl if Deputy Garl was there when the phone was seized, and Deputy Garl responded something to the effect of, "I can be if you need me to be." Additionally, the lead ASA relayed to State Attorney Office Administrator that Deputy was the one that was trying to be funny. We have the right to talk to the State Attorney Administration to see exactly what was said to them. Was this said to them by Ms. Bradley? Mr. Tillerin is the one that wrote this one, so we have a right to talk to him. Where did he get that information? But Ms. Bradley follows it up with the undersigned inaccurately, by the way, this is on the 28th of September 2023, the Brady notice. The undersigned inaccurately relayed to the State Attorney Administrators that she spoke with Detective Moretti regarding this incident, and that Detective Moretti explained that his statement to Deputy Garl was a joke, when she intended to relay that which is contained in the Brady notice on September 23rd, 2023. Additionally, the undersigned relayed this to State Attorney Administrator that the deputy was the one trying to be funny. Again, we have all these things dealing with what was related to administration. We have the right to see whether or not this is exactly what was related to administration. By whom? When? They've opened the door. They've waived this subject matter. We have the right to go into it. Those are the reasons. So she did not totally do it.
Thank you. Anything else?
The only thing I want to point out is regarding the cross-examination question is, there was never an objection by the defense in this particular matter when Mr. Klinger cross-examined. Now all of a sudden, there's a problem. I've not had the privilege of seeing the transcript of the other case, the other motion, but I was submitted to the court, from my understanding, that there was an objection then. Why all of a sudden now is there a reason to now call at least Mr. Klinger regarding this particular matter? Whatever Mr. Klinger said was on the record. We didn't have it before, it was attached to the motion. doesn't give the defense a reason to call Mr. Palmer. And this hearing, which this court is going to engage in, doesn't give the defense the opportunity to go spaghetti at the wall to call anybody in administration regarding this particular issue. This false name isn't even mentioned in the motion. As far as privilege is concerned, we're talking about a work product privilege, which the court discussed, which is privilege discusses in the universal name, which was argued in the previous one. So based on the arguments within the motion and the arguments here, so it would ask me to quash the subpoenas, the state attorney prior, or chief assistant Paul, Mr. Killeran, Ms. Bradley, and Mr. Palmer.
Thank you. And so you don't even know if you have service on them, subpoenas, correct?
We do, we serve the state attorney's office, so I know we can service through that.
So they were served through the state attorney's office, place they
I
were.
just need to advise the court. Well, I'll the court.
Anything else? Well done. All right, the motion's granted. I'm going to squash the subpoenas. I'm not allowing the subpoenas to go forward. Testimony of the state attorney, for the same reasons I gave before. I understand certain things may have changed a little bit, but I'm not allowing those definitions to go forward. All right. What's the next motion you're calling, Ms. Boutros again?
Your Honor, can we have a 5-minute break? I want to see how we're going to proceed now.
Sure. I don't want you to go anywhere. I want you to stick around. Mr. Klinger, you're going to stick around?
Yes, sir.
Thank you.
Your Honor, I have to do a Zoom hearing, a Dade County Zoom hearing. Can I use your?
Sure. All right, we're in recess. Thank you. appointed as counsel and the assistant state attorneys.
Yes, sir. You asked before we go up with the next motion. I think right now we have the motion to dismiss motion for review.
Thank you.
Your Honor, we talked outside of the presence and with the court's permission, of course. What we'd like to do is that calling this to stipulate her testimony that you previously heard during the first motion to dismiss and refuse, and during the motion to suppress. And we would stand by both sides of those testimonies. That's fine.
That's fine.
Sure. With that, we have no other witnesses that we can call. We would have called those other witnesses. The purpose of calling those other witnesses would be to show the institutional bias, the institutional breakdown of the state attorney's office. And we would be calling those witnesses to show that they have made a decision to basically throw one of their own, Ms. Boutros, under the bus, call her a liar, and ruin her reputation in order to bolster that of Detective Peretti. And therefore, we believe that there is certainly a conflict within the state attorney's office, and that's what those witnesses would have proven. That's the best that I can proffer right now, because I haven't had any opportunity to take their depositions or speak with them. So I can only do it in a cursory or an overview fashion.
Thank you.
As to the motion itself, Your Honor, there are really two facets of the motion. There's the first part of the motion that deals with the state attorney's actions in this matter, starting with Ms. Bradley, going up to the head state attorney's office, and then coming back down to these prosecutors. And what I've outlined, and I'll rely on a lot of what's in the motion. I've learned that this court is incredibly thorough, reads the motions, reads the case law, so I don't want to, that's another thing to beat a dead horse. The bottom line of it is Ms. Bradley is informed by Ms. Boutros that she can't work with, well, Mr. Killerman is informed by Ms. Boutros that she will not work with Detective Peretti any longer. There is certainly, as far as the state's concerned, exactly what was said in that room and whatnot, which for this purpose is really irrelevant. What's relevant is the fact that once Ms. Boutros does inform Mr. Killerman, it starts going up the chain of command that Detective Peretti has solicited perjury, that Detective Peretti was willing to perjure, whatever the exact terminology is. And it goes up the chain of command, and it then eventually, as you've heard from Ms. Boutros, gets in front of State Attorney Mr. Pryor, and in some fashion, it is decided that this is Brady material. And so a decision is made, and this is in, I'm going to say, I don't have the exact dates, I don't want to say I don't have the exact dates, but anyhow, well before the first trial. And a decision is made that this is Brady material. I'm not saying they made a decision that it is admissible, but being Brady material is a broader category than the court eventually admitting that material. But anyhow, they make the decision that it's Brady material, and I still think that obviously that's admissible. And trial goes on. And Ms. Boutros realizes when she's watching the trial from home, there can't be any Brady material that was given. So when the trial's over, she looks into it, and she finds out, in fact, the Brady material wasn't given to us. So what happens to Ms. Bradley? Nothing. Ms. Boutros won't allow it to die, this issue, and eventually the state attorney's office, Ms. Bradley sends out a Brady notice. Mr. Killerman then files an amended Brady notice saying that what Ms. Bradley said was incorrect. And then Ms. Bradley turns around and corrects Mr. Killerman in saying that he didn't know what he was talking about. What happens to still going to be prosecuting away. So the state knew that the prosecutor on this case disobeyed their order, their directive, to issue a Brady material. That the prosecutor on the case allowed the case to go to trial. The case ended up with a hung jury, and then afterwards, the state attorney's office finds out that this prosecutor did not send out Brady material. Then nothing happened. Why? Because this state attorney's office cares about one thing, and that is women. So she's still on the case. Miss Boutros, on the other hand, is the classic whistleblower. She had no reason to attack Mr. Detective already. She had no reason to have any ill feelings about him. She had certainly no love for Mr. Demings. And as the state went out of its way, she's not really too fond of Mr. Benjamin. So there's no reason why she is going to be lying. The state may never have used the word liar, but they've used the words that she told untruths. They've used every synonym for liar against her. So anyhow, as this whistleblower, the state acts as many businesses do. Some businesses respect that whistleblower. Other businesses decide the whistleblower is the evil. And that's what this state attorney's office has done. They've decided that Ms. Boutros is the evil one. So you know what? Let's shoot the message. Not the message, the message. So they go through her record for 20 years. They analyze transcripts. They look for words. They pick out words that were used and leave out others. And I'll get to some of them in a second. But they do all that to assassinate her character. They do all that, and yet she's a member of their office. That alone is an inherent conflict. But when you do all that, that gets us to the third part. That is the rot, as they call it, of the state attorney's office. That this state attorney, finding out about Miss Bradley, and then Miss Boutros being the white knight, so to speak, she did wrong. She is the one that gets punished by this office. So they disparage her character. They bring up bar complaints. They bring up anything they can about Miss Boutros to make her look bad. And what happens? The state attorneys in this courtroom, who I've said, and I'll say it again, you get to be fond of people when you work with them unless you get to hate them. And I'm fond of all three of these people. But what they did to Ms. Boutros on the witness stand was reprehensible. Her office is only a couple of doors down from some of these people. They know her integrity, and they try to just dismantle. Why? Because winning is everything. So now, we get to the second part. And the second part is that the state has already made its intentions known, that they intend to cross-examine her, and apparently brutally. So we now put on Ms. Boutros as a witness. As you heard earlier today, the state has now acknowledged that these matters are intertwined. There'd be no reason why she can't testify as to what happened with Detective Moretti and his supporting perjury or seeking perjury. So she testifies, and now the state comes with all their arsenal of weapons they have, and they impeach her. Well, what does that say to the jury? That says even the people that she works for don't believe her. And that nullifies her credibility, not because of her truthfulness, but because of her status as being a state attorney in this state attorney's office. Now, there are cases in which the state attorney has had assistant state attorneys as witnesses. I found no case in the state of Florida where the witness is adverse to the state attorney's office. Every case deals with that assistant state attorney who is testifying being on the state attorney's side, being a witness for that state attorney. Here we have the opposite influence. In the case of United States versus Johnson, I've cited it in my memo, 690 Fed Second 638, 7th Circuit, 1982. Court stated, first, the rule eliminates the risk that a testifying prosecutor will not be a fully objective witness given his position as an advocate for the government. Second, there is fear that the prestige or prominence of a government prosecutor's office will artificially enhance his credibility as a witness. Third, the performance of the dual roles by a prosecutor might create confusion on the part of the trier fact as to whether the prosecutor is speaking in the capacity of an advocate of a witness, thus raising the possibility of the trier according testimonial credit to the prosecutor's closing argument. Fourth, the rule reflects a broader concern for public confidence in the administration of justice and implement the maximum that justice must satisfy the appearance of justice. How can it satisfy the appearance of justice that we put on Ms. Boutros to contradict Detective Moretti's rendition, to impeach Detective Moretti, and then the state attorney's office gets up there and impeaches her own office, her own fellow prosecutors? There is no way that Ms. Boutros' testimony will carry the weight that any witness's testimony should carry, which is it sinks and swims on its credibility, not on the fact that because the people cross-examining her are from her same office. There's nothing that one can do to get around that prejudice. That when they cross-examine her and they try to make her look like a liar, they're saying, we know she's a liar. We believe she's a liar. They're not testifying for her credibility. They're doing the opposite. They're testifying that she's not credible. The state filed that long response, state's response to the defendant's third motion to dismiss or for violation of due process and double jeopardy and or motion to recuse entire state attorney's office of the 17th Judicial Circuit. And in it, number 8, they put, in ASA Boutros' deposition to defense counsel, she stated that the investigation into Ms. King's suspected witness tampering was separate and apart. But of course, they left out that in that same sentence, Ms. Boutros answered at that time. So it was a qualifying that at that time, but they left that out. On page 4, number 12, they say what she said is untrue. As I said, that may not be, that saying things untrue or not true is the same thing as saying they're lies. And then on page 6, number 14, things that they've looked at for this Boutros. They looked at the subpoenas that she signed with Detective Moretti. They went into the screen shots of text messages between her and Detective Moretti. They went into emails with Detective Moretti. As I said, They went into the fact that she may have been involved in the case within 2020 when she said she didn't believe that she had met her before. They put in there a photograph of Detective Moretti and Ms. Boutros walking back into the state attorney's office, as if that proves something. They just both had gotten done with the deposition, with the seizure of the phone from Ms. King, and they were both going to the state attorney's office. But they're doing everything they can to make her look like she is a liar. They attach Mr. Benjamin's letter as if that has any relevance whatsoever, other than it made this court smile, and that's always good to see. But they attach Mr. Benjamin's letter. Of course, the state attorney's office pretty much told Ms. Benjamin to go pound sand, but that's another issue in and of itself. They put in their bargaining claims against her. They've also put in there another complaint made by her by a public defender, and if I have my facts correct, and if I'm not, I apologize, but I believe some of the prosecutors in this courtroom actually testified on Ms. Boutros' behalf in that event, that the person that was formed with, that filed the complaint had actually been harassing others. Anyhow, Your Honor, I can go through all this. What I was going through is just to show the fact that the state is using every weapon they have at their disposal, everything that they can think of, to ruin, to destroy the whistleblower. If the court will give us liberty, Mr. Benjamin would like to add something.
There isn't anything Mr. Benjamin just went over. In his absence, the last couple of days, we were able to identify and brought, and I asked Your Honor, 6 executive assignments that Mr. Pryor petitioned and got from the governor to have another state attorney to recuse himself and have another state attorney's office take over. If I could, I gave them the state office just to see them yet, but they're all copies of the actual ones with the stamps on, and I think Your Honor can take judicial notice of those, if I may.
Objection.
I'm going to object to the relevance, Judge. There's no statute regulating executive assignments. That is something that's within the discretion of each office. So what was done in other cases has no bearing on what's before the court today.
Have you seen?
No, not.
So,
And my thought regarding your request to do that was defer ruling on that.
Sure.
What's next?
and just to go over them, they are a group of 6 of them that we were able to identify just in the last day or so. So, and basically they are that Mr. Pryor claimed that in the abundance of caution, so that it wouldn't be the appearance of impropriety in the rules as to him possibly having a conflict, that he recused himself in these 6. One was because, and they were all lesser types of cases, misdemeanor, DUI, leaving the scene, battery, those type of cases, but it's because a victim was related to somebody in the state attorney's office. The defendant used to work at the state attorney's office. And there's a whole list of them, I'm going to give them to you all. And of course, everyone is different. The discretion of the state attorney's office is there, but that's the point. The point is that the discretion utilized by Mr. Pryor in doing these 6 show that he has recused himself when there's an appearance of a conflict of some sort. And in these 6, these appearances of conflict are de minimis compared to the one that we're trying to outline here. And, the state keeps going on and on about the fact that this issue is about a discovery violation or a Brady notice. If you really think about it, Your Honor, if in fact the facts are true, as Ms. Boutros swore on the road, 20 years of experience as a prosecutor, the chief witness, sworn police officer, solicited another police officer to commit murder. It's a little more than possibly withholding evidence or a grave violation as the evidence. This goes to the meat, the fact that the whole issue of the credibility of the one who investigated this entire. And so it isn't just a grave violation. It rises to a different level. And that's why if you compare this set of facts, to these 6 where he readily recused himself on other things that I've already said are de minimis, I think that this state attorney's office, by embracing Detective Moretti over one of their own, who's been there for 20 years, is inherently the conflict of why they didn't use it. May I approach?
No,
Oh,
I haven't decided whether I'm going to take judicial notice. It appears to me just as permissible judicial notice, not mandatory, but regardless, the state had indicated they had, I know you showed it
Okay.
to Mr. Buckaloo, I indicated Mr. Justice Griffin was arguing he hadn't seen them, and so I don't know what his position is on, so I'll defer ruling on it. You can
Okay.
file them if there's no objection, we can talk about it.
thank you.
I would still be objecting for just looking at these, it's either an employee or a relevant employee was arrested or a victim. Again, despite the fact that it's discretionary, it's also completely different where we're dealing with a witness, and I do address.
Thank you. As I said, I defer. Anything else you have?
No, no.
Anything else, Mr. Harris?
Yes, Your Honor, just want to finish up with the fact that what we're asking for is one of 2 things. The case be dismissed under his credo that I cited and Glosson, because it's just a breakdown of the process within the state attorney's office, and there's an institutional problem when it comes to this case within the state attorney's office, and then the alternative to recuse.
Thank you. Yes, sir.
Judge, just to start with, I think the defense keeps conflating the tampering issue. There are 2 tampering cases. One involves Mr. Demon, what was going on in jail, passing kites and information as it relates back to Brian Hamilton. That is completely different from the investigation to Mr. King. So I want to be clear that when we reference the investigation to Mr. Demon in response, we're referring to the cases he's charged with, not the Mr. King investigation. So it's still the position that that investigation is separate, and I do address that in the response, which counsel points out. To start with the state, when we first said that we were not going to be cross-examined, because as Mr. Aronson points out, if in fact Ms. Boutros is coming forward saying this information is something that happened in the case, we of course want it to go before the court. As she's testifying, that is when Mr. Klinger realizes something she just said is not consistent with her deposition. It's an inconsistency. He crosses on that limited issue about whether the investigation into Ms. King was related or not, because that was a change in her testimony. Then we fast forward to the deposition of Detective Moretti. In the deposition, that's when he's asked if in fact he had worked with Ms. Boutros afterwards, and he says yes. Because Ms. Boutros testified she didn't work with him again. Another inconsistency. That's what prompted the state to look into this, because as I laid out in my motion, no matter who you are, if you take the stand, you put your credibility at stake. And so now we have concerns that things are not lining up. And that is when the state went into, when we went into looking into exactly what was going on. And recall, we've never called Ms. Boutros a liar. The purpose of impeachment is inconsistency. The court and the jury would theoretically hear a statement was made inside court, a statement was made outside of court. Those statements don't match. Don't say the statement outside of court is true and the one in court is false, or the one in court is true and the one outside of court is false. What the jury instruction basically reads is, if there's an inconsistency, you should not consider the witness's testimony as reliable. That's it. So what we have now is a witness whose testimony is not consistent. When we talk about the other issues that we raise in our motion, it's because the defendant is vouched for Ms. Boutros. And all we have laid out is that, again, the evidence does not support this claim that they're making. So I've gone through all the case law that talks about recusal and dismissal.
Let's go through some of the pleas that were filed here, though. We have a notice that was filed. It's not a notice, it's a response, October 6th, by Mr. Klinger from the state, which I appreciate. It's entitled State's Response to Defendant's Motion to Recuse State Attorney's Office of the 17th Judicial Circuit in Fort Broward County, Florida. And at page 2, Mr. Klinger writes, moreover, the state has not created a dispute in the evidence, just as it did in the prior trial. The state will not be calling any assistant state attorneys or the elected state attorney, for that matter, as witnesses during the upcoming trial. In addition, if in fact the defense decides to have ASA Boutros testify as a defense witness, she will not be cross-examined by the state. There is no inherent right to disqualification when a member of the state attorney's office is called as a witness in a case prosecuted by the state attorney in the same office. And it cites to a case there. That's Mr. Klinger when he represented to the court. Then at the hearing, page 88, Mr. Klinger says, they say the state's prejudiced. And then they also say there's a conflict, but there is no conflict. We don't dispute anything that Ms. Boutros said on the stand. Didn't cross-examine her on anything other than just to clarify a couple of issues. But it wasn't the facts. We agree with them. We probably could have just stipulated to most of her depositions, so there's no conflict. Then in my order, as I indicated before with Mr. Aronson, I basically cited to that in the order regarding defendant's motion to recuse the state attorney's office. I indicated, there's no conflict. The defendant has failed to demonstrate how he will be prejudiced by the state attorney's office prosecuting this case, notwithstanding Ms. Boutros and Ms. Bradley testifying in trial, particularly in light of the state's representation that they do not plan to attack the credibility of Ms. Boutros in trial. That's what you told them, or Mr. Klinger did. And now it's a different story.
Because cases are fluid. As I told the court, when we spoke to Detective Moretti and when he gave the deposition, more information came to light. And of course, as prosecutors, we're duty bound to investigate and discover what the truth is. And that is the result of it. Whether it's our office or another office, the same investigation would have resulted. Because any witness who's going to be taking the stand puts a credibility stake. Had the roles been reversed, had Ms. Boutros witnessed something that would have been germane to the case and we had followed her, certainly the defense would have attacked her credibility. Because that's the nature of our system. That's advocacy. It's an adversarial system. We are allowed to disagree on facts and law, and that's for the court to resolve or for the jury to resolve, depending upon where the issue lies. But what we're dealing with now is a witness called by the defense who presumptively was telling everything as she saw it, and then as information came to light, perceptions changed. Cases are fluid. And so what we've done—
Representations are fluid too. We're not going to cross-examine her as a witness if she's called by the defense. We're not going to cross-examine her. That's fluid too. Your representation of that, that's fluid. Doesn't mean anything. I can go ahead and cross-examine.
It's based upon the facts of the case, Judge, as they come to light. And so when we got into the case and started looking through it, and we had the deposition of Detective Moretti, when he testified at deposition, no, after that, there were text messages. She did subpoenas for me. There was a warrant that he sent her. She didn't approve the warrant, but he sent her a warrant review. She was still working on the case. That's in conflict with what she testified to. So we're like, okay, well then what else is there? And this is the net result. So whether it's me cross-examining her or another office, she's going to be subject to cross-examination. going back to the case law that I talk about, recusing an office is literally like the last measure that the court has to do. And in this instance, it doesn't demonstrate how the defendant is prejudiced. The witness is who they are, their history is who they are, whether it's us presenting it or another party presenting it, she's going to be subject to the same cross-examination. That is the nature of our process, it's the nature of our system. What I've laid out in my motion, or my response, I should say. I know they keep bringing up the Brady issue. The court decided that previously. We addressed that as race judicata here. The only question that remains is just the fact that now Ms. Boutros is subject to cross-examination. But as I've laid out in my response, particularly starting, I do discuss dismissal charges as well, but dismissal charges as well as disqualification of government, starting in paragraphs 35 and 36, is an extreme and drastic measure. It's just simply not one that's called for here.
Anything else? Yes, sir.
Briefly, Your Honor. If I'm hearing the state attorney correctly, what they're saying is nobody can rely upon the representations of the state attorney because they are only as good as the second that they are said. And 1 second after they are said, they have no meaning. I think this is, the state attorney's office is one unit. They can't have, for expedience say, have Mr. Klinger come in and say, we're not going to cross-examine Ms. Boutros because that was maybe the linchpin of why you would do the way you did previously. And then later on, do the opposite and now contend that they intend to do the opposite even at trial. Representations mean something. It may actually be unethical. I don't know. I did not look into it on the ethical part. But to represent something to the court and then turn around and do the opposite. I mean, we all have some allegiances to the Constitution, to whatever. But there's a, I don't know where it falls, but you represent something to the judge. It better be true. You represent actions you're going to do in the future. It better be true. Well, this state attorney represented, through his assistants, but this state attorney represented that Ms. Boutros was not going to be cross-examined and that they agreed with her facts of the case. And now this state attorney turns around and says, we don't agree and we're going to cross-examine her. We wanted to take the depositions. I wanted to find out why Mr. Klinger would make that representation in court if it did not come from the higher-ups, from the state attorney. And I'd like to know why Mr. Griffiths cross-examined Ms. Boutros the way that she did, and why they are now going into things. Does that have Mr. Pryor's certification, his stamp of approval? Because if it does, quite candidly, it does show the rod of the state attorney. That no matter what it takes, Mr. Klinger, you say what you need to say if we want to win this motion. Mr. Griffiths, you say what you need to say because we want to win this motion. Even if they're opposite, it doesn't matter. Winning at all costs is everything in this case. This is high profile. And yes, Mr. Benjamin presented you with documents that the court hasn't considered yet or not as to the recusal. This case would scream for recusal, but it's not being recused because it's high profile. And this is the splash that this state attorney wants to make. Your Honor, as far as recusal goes, so let's start dismissal. I cited Izquierdo versus State previously. It is 746 Southern 2nd, 120, 1220. This case ended up not getting dismissed because it went up to the 3rd DCA, who basically remanded it for a further factual finding. The appellant, who the defendant, chose to put on no testimony. So the court then, when it went back up to the 3rd, they pretty much said, we were hoping for more testimony. You didn't get us more testimony. You lose. The But they said here, there was no showing that the misconduct complained on the prior appeal represented an institutional policy of the state attorney's office. That's what we've been trying to prove. But I think you've got an institutional problem here with the state attorney's office. You don't fire Ms. Bradley for insubordination, for not sending out the Brady notice. You keep her on the case even though she's been insubordinate. You send out your own, you send out you force her to send out a Brady notice. She doesn't like it. Mr. Killoran sends out a Brady notice. She doesn't like it, and she overrules Mr. Killoran with a new Brady notice. Nothing happens to Ms. Bradley whatsoever. Ms. Boutros, on the other hand, as you've seen, is attacked in all different fashions by the state attorney's office. Now, the institutional. The state attorney, did he authorize Mr. Klinger to say, you know what, we're not cross-examining her? And did he authorize Mr. Griffiths for putting in the motion that they are going to cross-examine her and for his cross-examination? It's institutional. It goes from Ms. Bradley up to the state attorney and back down to the prosecutors in this court. When it comes to Jamell Bevins, for whatever reason, there is an institutional bias, prejudice, and rot that demands that this case be dismissed. And in the alternative, that I would request that the state attorney's office be recused. In Nestler versus State, 314 Southern 3rd, 287, 220. In the dissenting opinion, and I only read the court because it's just to get the flavor of the law. We explained in Rogers that although we have stated that the appearance of impropriety created by a certain situations may demand disqualifications, we have evaluated such situations on a case-by-case basis. Everything. And that's what you're going to find in the law, basically, that everything has to be looked at a case-by-case basis when we're talking the way we are. This demands disqualification. What's gone on in this case with this state attorney's office demands disqualification. The state cited Brown versus State, and I'm going to cite that, 455 Southern 2nd, 583. In the concurring opinion, I agree that the state attorney and his assistant state attorney should not be disqualified in this case. Of course, the assistant who prosecuted the case was not the one who testified at trial. There was no showing of any prejudice to the appellant in this case, but such could be so in another case. Thus, I agree with the result here, but am reluctant to join the majority opinion, which seems to announce a per se rule. Again, there is no rule. It's up to this court to decide on a case-by-case basis. One last. So one of the first cases in this matter is State versus Fitzpatrick, 464 Southern 2nd, 1185. It's a Supreme Court of Florida 1985 case, obviously. In the last paragraph, they say, we find, however, that imputed disqualification of the entire state attorney's office is unnecessary when the record establishes that the disqualified attorney has neither provided prejudicial information relating to the pending criminal charge, nor has personally assisted in any capacity in the proceedings in the prosecution of the charge. Well, the recused state attorney in this case not only took part in the case, she tried the case. And half of the information the state has right now has been gleaned from the work that she has done. Pursuant to that case, the state should be recused. Again, we find, however, that imputed disqualification of the entire state attorney's office is unnecessary when the record establishes that the disqualified attorney, Ms. Bradley, has neither provided prejudicial information relating to the pending criminal charge, nor has personally assisted in any capacity in the prosecution of the charge. there's no way that it can be argued that she did not take part in the prosecution of the charge. Your Honor, the case should be dismissed, but if not, it should be reviewed.
Thank you. What other motions you have, Councilman?
On this matter,
Today, yes.
excuse me,
Today, any other motions?
Well, Judge, we have a couple things I'd like to discuss, if we can. You ruled, on the.
Motion for a year?
I'm waiting to see where you're
Well,
going.
you ruled on, the motion for rehearing, on the motions to suppress, that you wanted some evidentiary hearing. I wasn't thrilled to read that, but it is what it is. My thoughts are maybe we can discuss scheduling that right now.
That's on my list. So that's, we think along the same ways. I don't know when, my understanding is from Ingrid, my J, that she's going to try to coordinate some dates.
Well, we actually-
Process.
I know, Ms. Buckley, we were working on a calendar. I don't know if we can do it right now, because I know the other parties aren't present, but
Well,
we want to see.
the first thing I wanted to bring out was, I think that this is a multi-day hearing. I mean, because this is how I see it, that you are going to say what the evidence is, where it came from, have somebody testify to that, and then you're going to need to have somebody testify as to where the inevitable discovery would have come from, how you would have found it. So you have, for each piece of evidence, you have a train that you have to do, and you have a lot of pieces of evidence. I thought this would take 3-4 days.
I don't know how long it's going to take. I don't know what the witnesses say. You'll call whatever witnesses you think you need to show that. But my thought was, it really wasn't addressed, the inevitable discovery or the independent sourcing. And therefore, my thought was that we give you a chance to argue those things and show me where it was.
Yes, so thank you, Your Honor, for that. We are asking if we could hear it as soon as possible. I did speak with the witnesses. Tuesday wouldn't work for us. Because of, in light of the fact that the court's previous ruling, obviously, on motion for rehearing and on motions to suppress themselves. Obviously, Your Honor's ruling on this reconsideration of the different evidence that we did not address earlier would determine whether or not we potentially take an appeal, and obviously, the appeal court's ruling on motion to suppress them now in 15 days.
So I want to expedite it as well. So I don't know when, but I did agree to take a case starting Monday. It's 2 or 3 day case is what I'm told. Sometime later in the week, good
I'll make it work.
for you?
I've left as best I can Fridays to be available for anything that the court needs.
I don't know how long it's going to take. You think you get it done in a day?
I think so. If anything, we may spill over a little bit into the next day, but not much.
Can I ask something, and certainly I don't think the state's obligated to do it, but I think we could streamline things if you could basically send an outline of what piece of evidence that you were seeking to have admitted, what search warrant it came from, and maybe even a blurb of how it would be inevitably discovered, and I think you're not
That's
obligated.
part of the reason why I granted it, because the way the motion was drafted, basically you were saying that it's overbroad and everything should be out and not itemize any particular thing. So I thought it was hard, the state was hard pressed to come back and identify something in particular, because you were just saying the whole thing, the whole, all of the evidence should be out, not anything specific. And that's why in my order I left it kind of like, you guys tell me what's in the dates. Regardless of that, I want to have the hearing. I'd like to expedite it. If you say it's going to be more than a day, if we come in, let's say Thursday sometime, and go finish it up on Friday, does that work?
Yes, sir.
Does that work for you, Mr. Aaron's?
Find it out right now.
There's that Thursday, I have a medical thing going on, but
I'll talk about that. It's on my list.
it's just that, it's a,
Can we go side by side while we're doing it?
Judge, while you are doing sidebar, can I step out?
Yes.
obviously.
Find out.
I'm sorry. discovery and independent source for Thursday and Friday, and is that good?
It is good. The only thing is we need a hearing on Friday for the Ms. Hamilton motion where they wanted to potentially testimony. We have a witness that will be out of the country after next Friday. So can we squeeze that one in?
How long is what's going to take? How long is it going to take?
Half hour.
Any problem?
Yeah, there's two motions.
One where,
The perpetuation of testimony or
Yeah.
use prior testimony?
one we're dealing
So
with.
we're doing both, there's two motions.
Well, which the one we care about is the one with Mariah.
And also the mother. Alicia,
But that is not, we have witness problems for Mariah.
yes. So, yeah, the witness that we violently have to call is only available when you go out of the country after the 19th, which is this coming. So a half hour.
Thursday? We can take care of that first before we go through this thing or something along those lines. Good?
We heard that his only availability is that Friday.
Only for work?
So put it on Thursday, and should be inevitable discovery, independent source, that portion of the motion on Thursday, Friday, and stick in your, whatever the motion is, give it to Gary, give it to Travis, and we'll put that down as well. All right.
It's the state's motion, Your Honor's often talking
And Judge, as we discussed sidebar, I'm going to be unavailable all or part of Thursday, but I'll be here all day Friday. But Stuart and Raven will be here with Mr. Aronson. So I just wanted to make sure that Mr. Devens is okay with that for Thursday.
Mr. Devens, again, I just run things by you. You have 3 or 4 attorneys. There's always going to be somebody here. I won't go forward without at least one of your attorneys here. But I always like to check with you. And so far, different attorneys have been in and out, even during the signature. You said you're okay with it, not a problem, and that if you were having an issue with it or you wanted to avoid subjection, you let me know. Is that correct? All right. So you're okay, and there's no objection to having Mr. Benjamin take whatever, care of whatever he needs, personal issue that he has, to take care of those issues. Is that right? All right. The other attorney will be here. Okay, perfect. And the same thing as whatever happened previously, it's the same thing. There's no objection to the way it's been handled so far, correct?
Correct.
All right, and the attorneys who've been present for your hearing, sometimes they're here, sometimes they're not, but you're satisfied with the representation, correct?
No, it's okay, Your Honor. 2 other matters. So one is, well, actually just one. We still have this emotional video defense motion to do today.
Good.
I'm sorry?
That's fine. How about the depositions? They were canceled, my understanding is. I asked about that, and the state told me that, I believe that you referenced that the defense had canceled the depositions that were previously scheduled. And I asked about whether they were rescheduled, and you said it's in the works or something.
So it's twofold, Your Honor. So one, I think some of them were canceled because we were still, I think, arguing in front of Your Honor about the scheduling of those depositions. So some of them were still kind of up in the air, but some were scheduled. Additionally, they have not been rescheduled, but I think part of the issue of us trying to schedule those is determining what evidence we actually have coming in with these motions that we've scheduled to be heard today, and also now next week with the inextricably intertwined and medical discovery, because that will make a difference in some of the witnesses who might not need to be closed.
And that might explain why Ms. Liberty has been asking me to ask the court, to ask the state, like, when are you going to give us dates that we can do depositions? Because from what I can tell, we've been reaching out for about 2 weeks, which would coincide with the ruling and everything, as give us dates, give us dates, give us dates.
So, cart before the horse, you suggest that we wait to see after Friday's hearing what happens? Or should we really, in the bunch of caution to try to get things going, give us some dates you're available and let us set depots now so that if every, I'm trying to we can move it along, but
That's fine. I'd suggest maybe setting the depositions then of individuals that don't have any, I guess, part of any of the motions when we're arguing.
We'll set whom we think is appropriate, but I think your logic will carry through.
That's fine, so if you want, send me a list of those individuals that I can get their
you want to
availability.
send us a list of dates.
Yeah.
And we'll send you a list of,
I'll get us some dates, and then we'll send you a whole package of dates and times.
I understand that some witnesses might not be available on certain days, I will help in assisting getting there,
I understand that.
so.
we can do that, but I think the first step in the project is give us dates, the state's available, and then we'll suggest the prioritization of the witnesses.
And if they're not available, we'll have to deal with it and dance around it. Please just give us dates.
No problem.
Well, they need to give you dates, I agree, and you need to give them the witnesses that you want the most, so it works at the same time, back and forth, all right? How about the other motions that are still pending?
So I have a list, Your Honor.
Well, Mr. Griffiths and I just spoke about one of them, Your Honor. That is the motion, I don't even know how it's titled right now, but it deals with the fact that there is the 1,400,000 Instagram motion, I don't even know, lines, text, you look at there's other communication devices where there are thousands and thousands of lines of data or whatever. Oh, is that what it is? Bottom line of it is they have to determine what they want to put into evidence. So therefore, then I can file a motion to say, you know what, it's only part and parcel of the whole conversation. It's irrelevant, it's inadmissible, or I agree with them. But until they can whittle down these millions of pieces of information, I can't file any motion.
And again, Your Honor, very dependent upon what the court's rulings are for us to determine what our evidence will be. So that would have to be one of the last motions to be heard. In addition, I've written out the motions that still need to be heard. We've already addressed the state's motion for reconsideration. We have filed a state's motion of moving to keep out ASA Lucas and ASA Bradley's testimony in trial. The defense filed a defense motion to compel Ms. Bradley's deposition, to compel a response to. They've also recently filed a motion to strike our business record affidavits that needs to be heard. There's also the second motion to dismiss, and Ms. Liberty indicated that she wanted to handle, we were asking to handle that today, alongside the third motion to dismiss that was filed by Mr. Aronson. The
I
state's
thought
motion.
we were part of both motions.
Yeah.
The second motion to dismiss has the little part in there that dealt with also a discovery violation with that documents or drives that we got. So that's why that's been put to the side. I promised the court, and I will stick to it, that when we argue that motion, I will readopt all the arguments that I have already done, and we don't have to go through this again as far as my part.
Additionally, we have the motion for consciousness of guilt that we filed that goes to tampering, but I know Ms. Liberty has indicated she wants to do those depositions of those witnesses first. The state's motion for prior testimony, which we'll be hearing next week. The state's motion for forfeiture by wrongdoing, which we'll be hearing next week. I believe there was a motion that will be filed by the state prior to us coming on. That is a standard motion that will that shouldn't take a lot of time. Then there's the defense motion only regarding the, this is the one that Mr. Anderson signed with the phone, social media, and business records, so that would be the last one to be heard. They have a motion regarding the defendant's gang affiliation, keep that out. They have a motion for the Apple Health data to be kept out, and then we are still working on, which should be filed by the end of this weekend, Monday morning, latest, our rapid motion that we've been working on.
What?
Rapid.
So, the ones that you can get her, agree on some dates, work it out amongst yourself, agree on some dates, get hold of my office and set them down. I need to get as much of this done as we can. I'd like to do it before council has indisposed, so to speak, and I'd like to get that resolved.
Judge, can we assume, which is a terrible word to say, but can we assume that we have Fridays in this courtroom if we need them?
Yep.
And just so you could potentially get a couple more days, you said Your Honor, picking up a trial next week for a couple
I
of days.
picked up two of them. I thought we'd be still in trial now, but I picked up two of them, one from Judge Holden, one from Judge Coleman, for the following sometime later in January, but they don't always go, it's, you know. So if it goes, it goes. If it doesn't, you know, we'll make ourselves available. But if you want to schedule hearings, just get with me, you know. Tell me when. I won't be taking any more cases. I mean, you know, the last couple of weeks been very little. I asked for a trial last week, didn't get one. I had it, but
We'll send over some post schedule that we can hopefully agree to.
right, the sooner the better, because I'd like to reserve the time.
I've already come up with my version of the schedule, I'll send it over to them today.
Okay, so
And
Standard.
The
the other
voting-
board will be back at the end of the weekend, so we'll try to conclude and let you know Monday about what our thoughts are.
the motion that's still pending now that you want to have heard today, you want to start that one now.
That's the ones.
Do we have a mechanism, did you pick up? the
I did.
We have a mechanism to play a thumb drive?
Asking the wrong guy. There's the man right there.
Okay. The doctor heard it.
Well, they may have it.
I assume that you.
They may have that.
We're resetting. Mr. Jennings, need a restroom break? That's why I was calling Mr. Perry. about the motion limiting Ray, the promotional video. So counsel, you want to play the video?
Yes,
Is that the idea? All right, just have it.
I have to mark this as exhibit and introduce, I don't think there's no objection.
All right, it'll be marked as, for the purpose of this hearing, as defense exhibit 1, I guess, and will be admitted for the purpose of the hearing. And you want to play it now? Go ahead and publish it, or you need some?
Yes, please.
We are fairly positive, John, that is not the entirety, so if it's not the entirety, you get to it, and that's the entirety.
I want the entirety, so can we play it to see what we have?
Sure, go right ahead, and you tell me if it's, you got the full one or not. I'll be at recess, you go ahead and play it.
What?
You're supposed to play your evidence.
I don't have.
Just go ahead, they can play it, just make sure it's the right one. I'm just gonna give it a couple of.
When you get it first, I'll plug it in.
All right, let's get back on the record again. This is State of Florida versus Mr. Devens. He's present along with his counsel and the assistant state attorneys. Did you get the video straightened out?
Yeah, unfortunately. Well, let me explain. Yesterday I was in 2 different hospitals for medical things. I mean, outpatients, but that's where I was. So I had my secretary make a copy of this and give it to Ms. Benjamin to bring here to court today so we could play it. She apparently copied the clip portion, not the full, so I don't have that. I apologize to the court. I apologize to opposing counsel. It's not how I normally do things, as the court, I think, has already seen. We've discussed it. We probably can knock this out. Mr. Griffiths and I counted watching the video. We think at 40 minutes total, we'll take it. So we just try to fit it in on Friday of next week.
Mr. Griffiths?
So my issue,
Have a Thursday.
I have it, Thursday's probably gonna work better on the
Thursday
because,
next week.
but we have to do the motion for rehearing Thursday, and that's kind of a priority, just in the timing. The issue with Friday is,
This
it's
one
a
has
day, and I have childcare issues.
This has low priority in the grand scheme of all those. We can find time to have it.
Just take it in another day, so.
Well, do you have your witness here?
Can I ask you a question?
I'm not calling a witness. The witness does not wish to be called.
Can I ask you a question regarding the exhibit? If you could agree on the exhibit, can you just send it to me and I'll review it on my own?
Sure.
Yeah, then it'll say it's 20 minutes and it'll just.
It's coming for arguments one after.
That'd be
Is
perfect.
that all right?
Yes.
We just ask that council show us the USB they drop off so we can make sure again that it's full.
Oh, that's what I want.
I'll tell
I
you
want you
what.
to look at it and make sure.
You do. You send the full one.
But
You saw what happens when I try.
And let us do it, and we'll send it right to them, let them approve it, and they can send it to the attorney. If that's okay.
That's fine.
Great.
Anyhow, because you're gonna be reviewing it, we only have then 20 minutes of argument, and I think we can do it next Thursday.
Just, we can send you an evidence.com link with the video.
That way when you go link, you can go to all
You didn't know
parties.
it's on there.
Oh, cool. Oh, no, I know, but that doesn't mean.
I'm not familiar with all that, but I'm sure that I have assistants here who can do it.
I said the same thing, and look what I ended up with.
So I have trusty assistants. All right, so then you're gonna table this, we'll do it Thursday.
Do you want to argument, because we can just send it to the judge?
No, I think you have to look at the video before you do that.
Well, no, what we're saying is, let the judge review it in chambers, and then Thursday, we can
Video.
move it in cabinets, but just start arguing. Exactly.
I thought we were gonna.
No, I think you need to look at it first.
We could do that too.
So thank you so much for your accommodation.
All right, and so, counsel, then we have nothing else today on Mr. Devon's case, right? Can I ask you though, counsel, to contact my office? Because I just got a message that the state may be no prosecuting the case I was hearing for Judge
Oh.
Yeah.
Crossing charges, I said, we're like, no,
so
You can't even form those words, can you?
no, I cannot.
but if that happens, there's some kind of witness issue or something like that, so it may be that Tuesday does open up, and so if you could just check with the office, and as long as everybody's available, we can just move it up a little bit.
I can tell the court I'm not available Tuesday morning. I will be here Tuesday afternoon.
Maybe Wednesday though, that's what I was thinking. You needed more time Wednesday, you have Wednesday, Thursday, Friday, get whatever you need. So I'll find out on Tuesday if it's gonna be no frost or not, and we'll let you know. You just check with my office, all
I'll
right?
try to find out sooner for you, Honor.
I will tell the court.
We're not going to rehear.
I'm in Palm Beach, Canada. Wednesday.
Whenever, I'm not trying to interfere with something you have done. It's just, if we can, if we have time, let's say in the afternoon, maybe we can do it.
Oh,
I just don't want to be one of these things where you, why didn't you tell us that?
No problem.
did your, does John know who the prosecutor are or what case name it is? I can look it up.
I don't have any information on it. I just know, handling it for Judge, I believe this one's Judge Holden, and then I have another one for Judge Coleman I've taken.
May we ask the court's indulgence to have 5 minutes to talk to Mr. Devens about the ruling yesterday? Because he really isn't up to speed, it would help us a great deal if that's okay with everybody.
I don't have an issue, it's really up to the jail staff.
Right, that's fine. I mean,
You're okay? control over that. It's up to them. You're okay? They're all right.
Thank you. Thanks, guys.
All right, so since there's nothing else to go, we're adjourned. Thank you.
Thank you, Your Honor.